The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. This is Charina Garcia, and we are having a webinar today called Handling Termination, Furloughs, and Wage Cuts in the COVID-19 Era. I have with me Cliff Rosenthal. He is the managing partner of our LA office, also an immigration attorney. And today we have a guest panelist, Erin McDermit. She is an employment lawyer and partner with M&H LLP, which is based in Menlo Park. So today, there we go. So just want to kind of go over what the presentation overview will be. You all are welcome to ask questions. We'll have a short Q&A at the very end. There should be a question box there for you that you should be able to see. And if you just type in your questions and send it, then we'll be able to answer as many as we can. So just to go over the presentation, all of us are living and breathing COVID-19. So what we really want to do is walk you through as HR or business owners, how do you live and conduct your business during this pandemic? Because of course, nothing is business as usual any longer. And how do we deal with the social and legal implications of COVID-19? Secondly, we want to talk about some legal concepts. What is wage reduction? What is furlough? What's a layoff? And we're going to go really into some deep dives into some challenging employment situations. So we have a number of Q&As that we're going to run through that Erin and Cliff will go through. And then we're going to provide some key takeaways. So one big note I want to tell you is that most of the employment information being provided is based on California law, right, Erin? California law?
That's correct.
Okay, and then she'll tell you when it's based federal law. Immigration is federal law, so anything Cliff tells you covers anywhere across the nation in the United States. Everyone's going to ask this, where can I find the information that I'm sharing with you? If you love this presentation, you can watch it again on our YouTube channel. So that's where you will find our slides and any information, any additional resources, handouts, and things like that. You could find it on our website, wolfsdorf.com. So I guess we're ready to go. And you know, as we talk about the COVID-19 landscape, what are we talking about? So as you call us, your immigration providers or your employment professionals, the answers we gave you 2 weeks ago are most likely different than the answers we give you today. And I think that's what everyone needs to understand, is that it's evolving every single day, because this has never really happened. You know, this is something entirely new, and we're all trying to deal with it on a day-by-day basis. So responding to the pandemic, it's not a one-size-fits-all. You know, it's going to be based on your company's needs, your workforce, and what works best for your situation. And you are having to make some really difficult decisions, and there's no real black and white answers, to be honest with you, because some companies are going to make decisions differently than other companies. Some companies are going to be very, very conservative, while others are going to, you know, not be as conservative. But the good news is the government is offering some flexibility in some respects because it's unprecedented times, and also tools and resources to assist the employees during this crisis. So let's start off with some basic definitions and some legal concepts as we go through this presentation. So Erin, can you define or give us some information on what is a reduction in pay?
I can. We'll start there. I know there's a lot of text on this slide, so I will walk through it and talk high level about these concepts. I do want to first just thank you, Charina and Cliff, for having me today. It has been very challenging last several weeks for everyone, and I just really appreciate the opportunity to be here discussing these issues with you both today. So a reduction in pay is exactly what it sounds like in some respects. You're reducing someone's pay. It has taken on a new meaning in this crisis because businesses are having to make urgent decisions sometimes within hours about what to do with cash flow and payroll and who needs to be kept on working, who can keep working, really complex issues. So this is coming up daily, hourly. Generally, employers can reduce pay prospectively. So going forward, you would never want to do it after the fact. And some states require that you give notice before you change it. So certainly you would always want to do it on a going forward basis. I always say look back at the employment agreement, because on a rare occasion, there might actually be some limitation on for that particular employee about whether or not you can reduce their pay, but that's going to be the exception. Typically, you can reduce someone's pay going forward. And then when you do that, you have to think about whether the person is an hourly non-exempt employee or whether they're an exempt salaried employee, because there are different rules based on whether they're exempt or non-exempt. For a non-exempt hourly employee, you can reduce their pay going forward as long as you pay them at least minimum wage. For an exempt salaried employee, even if you reduce the pay, the weekly salary, you still have to meet the minimum salary threshold for an exempt employee. So here in California, that means you have to pay them at least 2 times minimum wage. So depending on whether you're at the $12 or $13 an hour minimum wage for the state, you have to run that calculation and make sure that the minimum salary is still, it's about $48,000 or $54,000 a year. And if you're not doing that and thinking about that when you reduce an exempt salaried employee's pay, you could run into a wage problem there, or a problem with their classification as an exempt employee. So that's kind of the high level information we have to think about when we talk about reducing pay.
Okay, and then for furlough situations, what is a furlough?
Okay, so a furlough, which is all taken on new meaning in the last few weeks. Furloughs and layoffs are also what we're talking about with clients and businesses daily. A furlough is something that I think a lot of businesses were looking at right as this crisis erupted, because people want to reopen businesses as quickly as possible. So if they are able to. So a furlough is essentially a work stoppage. It's a temporary stoppage in the work, but the employment hasn't ended. It's basically a pause. So that's the most basic way to state the concept of what a furlough is. And it can be a complete stoppage of work, or it can be a reduced schedule, but that's what a furlough is. And the key is that the employment is still ongoing.
Okay, and then layoff?
A layoff, to contrast that with a furlough, is a termination of the employment relationship. So there's an end date, the person is not an employee anymore, and their benefits and all of the things that are attendant to the employment relationship have ended as of a certain date.
Okay, and then just a quick question. So for furlough, can you reduce their pay as well when you furlough, or is that just 2 separate concepts?
No, I would say that if you're going to furlough somebody, they may very well have a pay reduction. That's one of the reasons to do a furlough. So let's say you have to shut down your business operations for a few weeks because of this crisis, and people aren't working, they're furloughed, but you don't want to end their employment because you hope to reopen as soon as possible. You may also not be paying them during that time. Or if they have a reduced schedule and they're an hourly employee, their pay may be reduced because they're working fewer hours. You might even choose to lower the hourly rate. So certainly a furloughed employee could have their pay reduced. Now a laid off employee, it doesn't apply because their employment has ended.
So employers can choose 1, 2, 3, or all, right, in terms of their options as they're dealing with COVID-19.
That is correct. And this is one of the hardest things that I think people have been dealing with over the last few weeks, because many employers and businesses really want to take care of their employees and get back to work. And they have been looking at furlough options, but there are so many complications when you furlough people that some companies have decided it's actually going to just be better for the business and the employees if we just do a layoff, and then we'll rehire people if we can. But these are really complicated issues, and what we are spending a lot of time working through with clients.
Okay, so I think we're ready to move on to some questions here and get Cliff involved. So I'll start with you, Erin. My company needs to reduce wages and hours during the pandemic. What is your advice for implementing these reductions? And then what about changing an employee's worksite?
So I'll just talk a little bit about this because I think we covered some of this just now. Every call that we are getting about this with this question, we have to sit down and figure out, can the business keep operating under the local shutdown orders? If you can keep operating, then even so, everyone who can work remotely should be working remotely. And so we just work through the analysis of what can be done, how can it be done with each business client. Some businesses are not able to continue operations. Some businesses are pivoting and trying to, for example, let's just produce personal protective equipment. Let's make some plastic face masks instead of what we were doing last week. So that's what businesses are talking about. And if they need to reduce the wages and hours, we look at what is going to be the best way to implement that change. Are you going to be able to rehire people if you lay them off? Is that the goal, or do you want to furlough people? And we walk through part of what I discussed about before this slide.
Okay, so Cliff, Erin gave us some general overview, based on employment law, but how does that differ when you have non-immigrant employees working with you on a visa?
Okay, thank you, Charina. I just wanted, before I go into answering the question, I just want to echo something you said at the beginning, and that we're not really dealing with business as usual. Everyone knows that's not business as usual, but certainly when it comes to the immigration system, because the immigration system wasn't really set up for a situation like this. It was really set up to protect U.S. workers in cases foreign workers would come into the United States and undercut them, whether it be by wages or by benefits or some way to do that. So the regulations seem to be aimed at that, and we're trying to fit these regulations into a box which they were not intended to be fitted into initially, and it doesn't always have a good fit. And when that happens, we have different approaches, and a lot of what I'm going to say today there are going to be different approaches amongst different attorneys, amongst different companies. They're going to be conservative views, and they're going to be less conservative views, just based on the situation, because everybody wants all their compliance to be pristine, but it's going to be hard to do that in a total fashion as was done before, and some companies are going to have to make very difficult decisions in this regard. So in turning back to the question, dealing with the first question first, my company needs to reduce wages and hours. As most of you know, there are a whole alphabet soup of visas, of statuses, and it all depends on what status you're going to have. So, taking the most common professional visa, which most people or most companies use, is the H1B visa. The hours and wages are very, very much regulated. And generally, the rule is that any material change in the position requires an amended petition. So you virtually have to file a new petition in order to change any material change in the employment. So the question is, what is a material change in the employment? So certainly changing hours, going from full-time to part-time, will always be considered material, and you could never, and a company could never just reduce the person's hours from full-time to part-time. That would always be considered material and require an amended petition. At very least 35 hours, less than 35 hours a week would be considered part-time. And then the question, what about if there's a small reduction in hours? And that's more difficult. The regulations on one hand do say that that foreign workers, especially on H-1Bs, should have the same hours as US workers. But the real question when it comes to this is, what about payment? And really, if you reduce the hours, it's really going to be almost like a little furlough. And the way the immigration regulations for H-1Bs are set up is that any non-productive time, any unproductive time has to be paid for by the employer. So if the person is supposed to be working 40 hours a week and they work 36 hours a week, they could have a claim against the employer for that reduction in pay by virtue of the reduction of hours. So essentially, you might not be achieving much by by reducing the hours if you have to pay them anyway. So that's kind of the main the main issue with reducing hours of an H-1B. There may be some other ways to make it up later, future bonuses that are guaranteed, but essentially, if you want to reduce the hours and in fact reduce the pay of an H-1B worker, you really have to amend the petition. So that's really the H-1B visa, which is quite regulated. The good news is that if you file an H-1B petition, the person can start on the new hours, the new wage upon filing the application. You don't have to wait for an approval. So that's just one of the bonuses of having an H-1B. In terms of other statuses, generally most other employment visas require amended petitions if you go from full-time to part-time. There's certainly no wage reduction requirements in just about all visas. L1 visas, for instance, if you have somebody who's a company transferee, reducing the hours to part-time might require an amendment, but reducing the wage would certainly not. So that would be the better option in case of Ls, O1 visas, alien of extraordinary ability, or other types of visas that are employment sponsored. And then just two other statuses. If someone is on an F1 OPT, if they're on a STEM OPT, then there has to be an employer-employee relationship. There's no requirement as to a wage, so therefore you could reduce the wage whatever you could, but there must be at least 20 hours a week of employment that would be guaranteed, so you couldn't go below 20 hours in the case of a STEM OPT. In a regular OPT, the person must have 20 hours a week, but they can make it up in different ways. It doesn't have to be from guaranteed employment. And then finally, in terms of any other person that's on an employment-based, what we call an employment authorization document, or in the vernacular, an EAD. Those don't, that is not based on F1 OPT. Those folks, those employees can be reduced in terms of the hours, in terms of their pay as companies want.
Okay, so from what you've told me, it's kind of a hodgepodge. It's a mix. It could be dependent on the person's visa type. So the best advice is to talk to your immigration provider and find out exactly what are the options for each employee, correct?
That is definitely correct. But it's certainly in general terms, the H-1Bs, you have to be very, very, very careful.
Yes.
And the other visa status do have a little bit more wiggle room.
Okay, and then the change in employee worksite, if you could just catch that really quickly so we can move on to our next question.
Yeah, so essentially in the COVID-19 arena, we're really talking about people that now cannot work on site at the work site, but they have to work from home. Again, just focusing on the H-1B simply because all the other statuses I just mentioned have no real requirement of a work site. Normally a work site would not be, a change in work site for those other visas would not be considered a material change, but on an H-1B it could be. And generally the case law is it's clear that if the person is the new work site is within commuting distance of the initial work site, no amendment petition is required. What that really means is most people live in commuting distance from their work sites. At least those people in LA, that could be arguable, but working, you know, so most people work in commuting distance from their home, so their home site would not require an amended petition for an H-1B. And then the real question becomes posting. There's a requirement that jobs have to be posted at the work site in order to give certain employees notice of the job. It's not recruitment, but just showing that this H-1B is being filed on behalf of this person. So there are three major approaches that I've seen in terms of posting. One option would be electronic posting, and this would have to be to all affected employees, or similar employees, and would actually include contractors at the work site. And this can be done through email, it could be done through an intranet, it could be done through a website that's frequented by these employees. You know, that's, I guess, probably the safest and most conservative view. The next approach is, which I see, I would want to say most immigration attorneys are looking at this in some way, is physical posting at the home. And question is, what do you achieve by posting at someone's home when they're the only people, you know, there that see it? But that's,
yeah, I mean, the person who would see it at my home would be my 16-year-old son, and he'd know how much I make.
Right. Well, you could use a range, but assuming you don't, I mean, that is really the negative part of posting at home. It seems, you know, that you're supposed to post in the place of employment, and you know, if we consider your home the place of employment, there's basis to say that place of employment is where you have to post. What's the purpose of posting? If no one can see it, that's, you know, but you and your 16-year-old son, then you know, that it doesn't make too much sense. But you know, at least there's some sort of colorable claim, more than a colorable claim. I think some sort of basis to say that you at least you posting in accordance with the letter of the law. That's what it requires.
And I think I hear what you're saying, and I think that most employers, you know, really need to just kind of look at their population, what really makes sense. And then also, I think a lot of employers are asking us, like, what is the risk? Like, how, like, will we actually be audited? Will we be fined because we did not post at our employee's home? Will we be fined and penalized because we originally had posted the LCA at the work site, and then 2 years down the road, it's COVID-19, and then now you're saying we have to repost it. So, you know, a lot of things are going around. So we want to move to the next slide, but I just want to let the audience know that there's no right answer, I guess is what I'm trying to say.
I just want to echo what you just said. I mean, this is just a classic example of not business being as usual. And I just want to and it's just to complete, there's a third approach that says that you don't need to post at all at a person's home for the reasons that we've just discussed. And that's actually based on some Department of Labor minutes from 2017, which was already with this administration. So and these minutes pretty much say that there's no expectation to post at one's home. They're not binding, so it's not binding on Department of Labor, but it is inkling into what they consider the posting requirement it is, and they've stated that on record. So there's if for those that decide, those employers decide not to post at all, there's certainly some basis. And my feeling is, you know, if for companies that are trying in good faith to handle the coronavirus, you know, and protect the employees and do things as best as they can, I can't imagine that the fines and the penalties are going to be, you know, enormous in that regard.
Or even any is what I would say.
Yeah.
All right, so let's move on to the next question. So, Erin, you talked about repurposing an employee if their normal duties are no longer pertinent to the business under the current COVID-19 circumstances. So can you?
Under the current circumstances, yes, you can. And I will just preface this by saying this is, you know, overall, I don't know that I already said this, but I'll reemphasize it. Now, this is not just an employment webinar that we're doing here today. So I am talking in very broad brush strokes. And I just want anyone in the audience who says, well, why isn't she talking about this? Or why isn't she covering that? Or, you know, I heard something else about this, to know that there's no possible way I can kind of go into great detail on all the employment pieces. So there may be more that the audience knows that I'm not covering on a particular point, but these are just the broad brushstrokes. But typically in an employment agreement or offer letter, I'm going to have language in there that says the company can change the person's duties or title or role anytime based on business needs. The only people that maybe there's some restriction there, maybe some higher level executives have some protective language that limits, whether or not you can materially change their job duties. But generally, a business wants to know that it can make the changes it needs to make for business circumstances. In the current crisis, I would say that's in a way even more true. And to your points, as long as the employer or the business is doing things to the best of their abilities and trying to keep the wheels on the bus and keep things going, I think that would be looked upon favorably. And people are facing tough decisions where they might say, what is the core team that we need? What are they going to be doing? And what are we going to do with the rest of the team that maybe we don't need actively working right now or can't be actively working right now? And just working through those problems. But generally, I would say you can change an employee's duties as you need to.
Okay, so Cliff, I have a software engineer who's on an H1B and my company wants to start making masks. Can I do that?
Okay, so that's a great question. I had a couple of similar questions with hospitals. I had, for instance, nurses that were asked to provide masks and to do screening. And then I had at the same hospital researchers that were asked to help with masks and screening. And then this morning, in fact, I got a question about researchers where the lab for research is now closed, and they want to know if they can put them in a pool where they pay them the required wage and they keep their titles, but they help in the hospital rather than do the duties that were listed on the petition. And I think there is a conservative view and there is a less conservative view, as we've mentioned. I mean, certainly in terms of the immigration regulations, if you're on any of the temporary visas that are sponsored, the implication or the law, in fact, is that you have to come to the United States to perform the duties that were outlined in that petition. So in other words, in Charina's example, if you're a software engineer, you can't suddenly just start making masks, for instance. So generally what the requirement would be that any material, as we mentioned before, any material changes in the job duties in the position would require an amendment. The amendments become a little bit difficult because most visa status are based on a person's classification, on their credentials. So if their credentials are for a software engineer, they don't have credentials for making masks, for instance. So it's not always an answer just to say we'll do an amendment, because amendments would be difficult in these situations. Certainly, if this change was more permanent or this COVID-19 crisis continued for many months, I think it would be problematic for a person just to change job, just to change job descriptions, positions. The question becomes on a very short-term basis. Yeah. What would that be? For instance, even within the regular rules, it's not that the employee has to simply do research and is banned from doing anything else. Certainly, if it's a minority of duties, and certainly if it's a short time and a temporary purpose. For instance, if there was a big fire in the accounting department, the researcher wouldn't necessarily say, "Well, I'm sorry, this is not my research. I'm not going to help." So I tend to think on an emergency basis, on a very short-term emergency basis, there would be a basis to say that this would be permitted. It's not in the regulations per se, it's more implied. So therefore I would say this is probably a less conservative view, that employers would have to look at in the totality of their circumstances. But certainly going by the strict pristine conservative immigration law, there would be a basis to say that you would need amendments for that to happen or not to do that at all.
Yeah, and I don't think we could get an H1 approved to make masks.
Right. So I would say that's probably true. It wouldn't be
accurate,
one of
right?
the professional activities that you know.
Yes. Okay, Erin. So let's go to question 3. My company may need to furlough or lay off workers during the pandemic. What are the legal risks that my company should consider and prepare for?
Okay. I'm so glad we're talking about this. We touched on this a little bit, and just the basic concepts of furlough or layoff. When you furlough an employee, when there's a work stoppage or a reduced schedule, as I explained, they are still employed. And so what employers need to be thinking about there are a few things that come up with that. So continuing benefits, health benefits. What happens with the health benefits? It's if somebody who was working full-time is now a part-time employee. What if there's a group of those people and they are all now part-timers? The company needs to call the health provider and make sure that coverage can continue. Perhaps the carrier will say, I'm sorry, you need to flip everybody onto COBRA. So I've had some situations where people think, well, I'm going to furlough people so that I can keep the health insurance in place and so that they don't have to go on COBRA. That may or may not be true depending on the health provider. So that's an issue that can come up. We have the new paid leave laws that were passed a few weeks ago, the Families First Coronavirus Response Act, the FFCRA, which provides some paid sick leave and expanded family and medical leave. The employer pays for that sick leave and the family leave. It's provided for certain circumstances. But if you have an employee who's furloughed, who's working a reduced schedule, who then tells you that they are sick or they need to take care of someone who's sick, you may be obligated to pay for their paid leave. So you need to be thinking about that. And then here in California, there's some old guidance from the Department of Labor Standards Enforcement, the DLSE, that says if you indefinitely furlough an employee, you are supposed to pay out any accrued PTO or vacation as if the employment has ended. We know that we pay it out when the employment ends, but there's some old guidance that it has to be paid out on an indefinite furlough. But that's not case law, and there's no knowledge or certainty about whether the DLSE would take the same position in these circumstances. So those are the kind of issues that are coming up when you talk about a furlough. With a layoff, as I explained, the employment is ending. So you treat that as a termination, an end of employment, and then whether you're doing a furlough or a layoff, the employees will be able to look at getting unemployment benefits, and because you can get partial unemployment and you can apply for it even if you're furloughed. And then with furloughs or layoffs, with companies of a certain size, you also have to think about whether or not WARN laws apply. And there's a federal WARN Act and a California one, and I'm not going to go down that rabbit hole, but that's certainly something that companies of a certain size have to be thinking about. So there's a lot to think about when you look at furloughs or layoffs.
Okay. And then Cliff, in the immigration arena, what do we need to think about and prepare for?
So like in the other questions, there's going to be a distinction between the H-1Bs and other type of visas. Generally, with almost all other type of visas, there should be no issue with furloughs, assuming that all the other employees or similar employees are furloughed as well. The H-1B visas provide a big issue in terms of furloughs, simply because, as mentioned before, there is a requirement for the employer pay the employee for all non-productive whenever the employee is in non-productive status. So essentially, a furlough per se is not problematic on an H-1B, but you would have to pay the person the full wage during that time, which in most cases I would imagine would defeat the purpose of the furlough to begin with. So essentially, H-1Bs provide a big problem with furloughs. If you want to change if you want to change the conditions of employment, then there's an amendment that could be filed, and as long as it was filed, the change could be implemented. Otherwise,
so Cliff, the amendment could take 4 to 5 months because there's no premium processing, and I only need to furlough this employee for 3-4 months, right? So maybe that could work for me, right?
Yes, yeah, but then you'd probably have to withdraw the. Yes. The truth is, and this is mainly anecdotal, I've heard that H-1Bs are taking 4 to 8 weeks at the moment, and that's very similar to what the government's publishing. So it's
4 to 8 weeks or 4 to 8 months?
4 to 8 weeks.
Oh my goodness! Wow, the government surprises me.
Right. Well, I assume that all if no one's working on premium processing, all those officers are now working on regular cases. So I would hope. I can't guarantee that, but that's what I'd hope. So I mean, that would be a risky strategy in the sense that you could file the application in order to get the benefits of filing, and if things change, you could withdraw it. But if it's approved in the meanwhile, then you're ending up doing more and more applications to go back and forth between the different statuses you want for the person.
Okay. All right. So let's move on to number 4. So Erin, my company may need to withdraw job offers. What viability could we possibly face?
I love this one. So normally, in normal circumstances, if an employer has extended a job offer and the applicant has accepted it, and then you need to pull it for some reason, there is some risk to that. And I always want to know, of course, what are the facts of the specific situation? Why is the company considering pulling the offer? Because it's not necessarily going to be a huge claim or liability, but I think an applicant who has accepted an offer that is then pulled, if they've relied on that offer, if they've quit their other job, if they've expended some relocation costs, they might come back and say, well, wait a minute, this cost me a lot, and I need the company to pay for some of this because I relied on this offer. Under the current circumstances, we have to look at that issue a little bit differently, because a company might have had offers out to new employees, and they might have no choice but to either delay the start date or pull the offer and say, we hope to come back to this in the future, but right now we can't have you start. Our office location is shut down, and it's the kind of job that we can't onboard you remotely. So that's the kind of thing that could be coming up. So I'm a little bit less concerned about liability for pulling job offers in the current situation if there's a legitimate business reason why the company just simply can't proceed with onboarding the person. And different companies have made different decisions. Some have said, let's just postpone the start date for a month and revisit. And others have said, we can't foresee when we will be able to proceed, so we're gonna just rescind the offer for right now. And we're very sorry.
Okay, so Cliff, are there any special considerations in the immigration context?
Not really. In terms of immigration, the employer doesn't really owe a duty to the employee in terms of employing them. Just because they said they were going to employ them for a certain amount of time, it doesn't change the employment law that governs these situations as Erin described. So no, there's certainly from an immigration point of view, they could pull the offer without an issue as long as they take care of the employment law issues.
Yeah, we usually defer that to Erin. So Erin, those are your questions. Question 5, what can I do to help employees terminate during the pandemic who will qualify for unemployment benefits?
Well, here in California, I never like to make any guarantees about what the EDD will do, the Employment Development Department, in terms of awarding unemployment benefits to employees. But that's the agency here that processes unemployment applications. And right now, I know the EDD is overwhelmed and processing an unprecedented number of applications for unemployment benefits. So people who are furloughed, who have lost pay, can apply for partial unemployment, and laid off or terminated employees can also apply for unemployment. And then through the CARES Act, the Federal CARES Act, there is a special pandemic unemployment benefit that may kick in if the states, if the specific states adopt them, and that's the $600 a week benefit that you may have heard people talk about. And that is intended to extend some unemployment benefits to some people who might not otherwise typically be eligible for unemployment benefits. So anyone who's being partially furloughed or laid off, should be encouraged to go and apply for the benefits that they may be entitled to. And then again, as I mentioned, if you have furloughed employees who are still working to some extent, they're paid, they still have the benefits of their employment, as well as, PTO, vacation, perhaps sick leave that they may want to use, which may help them. And then also we have the Families First Coronavirus Act, which has the sick benefits and the extension of family leave benefits. So those are all the things we are looking at to try to help people just get through this crisis and get to the other side.
Okay. So Cliff, for my folks who are on non-immigrant status, what can our companies do to help them? And can they qualify for unemployment benefits?
So dealing with unemployment first, I think there are two issues. Number one is whether taking unemployment will be considered a public charge. And the second question is whether they're going to qualify. And that's really what Erin's just been talking about. Just in California, my understanding is that you have to show that you would be able to work immediately if given employment in order to get unemployment. And for certain people on visas who need sponsorship, that that qualification, that requirement may not be met. So that's all I want to say about eligibility. In terms of public charge, there's a new public charge rule. We don't really know how it's going to be implemented because it's really a few months old, but clearly included in there, it says that unemployment is considered an earned benefit. So assuming it's an earned benefit, you would be entitled to take the unemployment without it affecting whether you can apply for a green card or you can enter the United States based on being a potential public charge. So, without knowing exactly how it's going to be implemented in the future, it seems to be unemployment seems to be a non-issue for those those who have earned the unemployment benefit. In terms of terminate employment, what can you do? There's not too much you can do. I know many employers want to be very supportive, and they are very supportive. They help them with certain benefits, with certain services, helping employees, maybe giving them an hour consult time with a relocation specialist, with an immigration lawyer, just to help them. But once they're actually terminated, there's not too much they can do. And then I just want to mention, 2 other points is that people on H1B visas usually only have a 60-day grace period before they either have to file an application or leave the United States. So that could limit the unemployment they could have. And then certain F1 visas who are on the OPT, optional practical training, they also have a certain amount of time that they cannot be unemployed, or they will lose their status. So that's just things you have to look at as well.
Yeah, and when I get a lot of calls nowadays about this, and what I usually do is I kind of walk through with the client the different options, and many of them want to help the employees. So we talk about a variety of things. including perhaps not doing a lump sum payment of the severance and paying it out over a span of 1 to 2 months if it's a 2-month severance. So they're paid biweekly as normal, just to extend their termination date. Many of them have come to me and said that the employees come to them and said, you know, I really just, can you give me a leave? Can you do this for me and my family? So there are some other options we can look at to help the employees. So I recommend you reach out to Immigration Counsel as well to discuss that. So question 6, can my company I-9 new hires due to the pandemic? If so, how does that work? So Erin, I don't know if you want to take that question or you want to just defer that to Cliff, but I assume you can hire new folks during the pandemic, correct?
You can hire people, and surprisingly, I mean, there are businesses that are hiring, thank goodness. So that, of course, you can hire as long as you're complying with whatever the local, you know, shelter in place orders are. I don't have much to say about the I-9 other than just the general rule, which is that you're supposed to get it completed in the first 3 days of employment, and you're supposed to look at the proper documentation from the new employee and verify that they are showing you what they're supposed to be showing you, and then you complete the I-9. And I-9s typically, it's a very technical, people do them all the time, but it's a very technical document. I just want it done once within the right time frame. I want it done properly. I don't want people, you're not supposed to backdate them. You're not supposed to do odd things with them. Just fill them out, get it done. So that's what I generally say. And then I'll let you talk about what's new and different.
So Cliff, why don't you talk about what's new and different? Because typically when you I-9 someone, you must physically inspect the documents. So how are we going to do that when there's a shelter in place order and many companies are shut down or have very limited staff on site?
Yep, so that's the important question, and that second point that Erin mentioned and Charina echoed is the issue of physical inspection of the documents to show that, number one, the person's identity is the person who actually presented the documents, and number two, that the immigration documents are authentic. So generally, without the COVID-19 crisis, there were 2 ways to do that. Number one, the person would come in and the HR would physically inspect the document. The other way is what they call the remote agent. In other words, instead of bringing the Muhammad to the mountain, you'd bring the mountain to Muhammad, so to speak. And you would have somebody who was designated as an agent of the company go to the employee and look at the documents there. So those, you know, so for those 2, that still applies. I mean, certainly physical inspection and remote inspection. And then there's a third way to do it that's been added by ICE in terms of the I-9s during this crisis, and that is that there's an option for HR to review the documents electronically, which could be fax. I don't know who uses faxes today, but faxes, email, PDF, anything electronically. And then there's a requirement that within 3 days of normal operations resuming, that they actually be reviewed physically. They should be notated with a delay once they're actually inspected for COVID-19, as put down as a reason of delay. There should be some sort of written documentation of the remote onboarding and teleworking policy for the employee or for the company. This will only last for 60 days from March 20th or 3 days after the national emergency is declared over, whichever is first. And those are the 3 ways that are doing it, that they're doing it now. Just one thing is a little bit of a gray area. You know, ICE in its guidance, and it wasn't very, very detailed, said it applies to employers that are operating remotely. So it seems that this blanket exception to use, you know, virtual electronic inspection only applies for those that there are no employees at the work site. So this, in the current climate, a lot of employers, you know, are pretty much remote, but they have have some essential employees working at the work site. So the big question is, does this apply to them? in the next sentence after this exception is not listed, so to speak, I'll read it to you, and you can see or decide for yourself how clear as mud this all is. However, if newly hired employees or existing employees are subject to COVID-19 quarantine or lockdown protocols, DHS, which is Department of Homeland Security, where ICE falls under, will evaluate this on a case basis. So the question is, for those employers that are virtually remote, whose quarantine lockdown protocols does it apply to? The state, the city, the organization, the company? Essentially, the state's view, at least in California, is that there should be no physical, there should not be physical contact. Certainly, people together as much as possible. So I think there's certainly a basis to say that those that are trying their best. And I've got an example of a hospital who certainly don't want to get anybody together as much as they could in case to prevent the spread of the virus. So I think there's certainly a basis to say that if the state and the organization's protocols are to protect the safety of the people, I think there is a basis to say that this is the kind of situation that Department of Homeland Security, ICE, will evaluate favorably on a case-by-case basis. But the statement is the statement. It's not very clear, and there's certainly a more conservative view to be pristine if possible.
Okay, so which leads us to our key takeaways as we're wrapping up our webinar. So I think most of you heard what Erin and Cliff said, which is basically you got to follow the rules to the best of your ability. It's all new to us, to everyone, and we're all just doing the best that we can. Seek appropriate advice when uncertain or if changes expose the company to risk. So, Cliff, Erin, and I are extremely busy because we are providing a lot of guidance to help our clients go through all the changes. Make legitimate business decisions and document those decisions, extremely important. Anything that you plan to do differently or you want to justify why you're doing, just go ahead and document those. So if you're ever in the position of being audited, you can explain all of this and say COVID-19. Identify the non-immigrant employees as their employment can be subject to specific immigration laws and procedures. As Cliff mentioned, and as we went through all the different questions, you will be treating the non-immigrant employees differently, and you need to be aware of the rules and regulations surrounding their employment. Stay informed about legal updates as well as flexible guidelines issued by the government. A lot of our updates are on our website. I'm sure, Erin, your firm also has some updates available as well.
Yeah, we've been sending out alerts and trying to get things to people as quickly as possible. But I think there's no lack of information out there if people are trying to stay up to date. I think the trick is staying up to date because there's just so much happening so quickly.
Yeah, and then document your company's remote work policy, just so you have that all in play. We have about 5 minutes left, so we have some questions which I'll just throw out, and then I think, Erin, this one is yours. What happens if a furlough becomes a layoff?
Well, so we anticipate that will be happening, and that companies that initially tried to furlough people will then end up doing a layoff. What happens is you just keep going through the process and the analysis. So I don't know if there's a specific question about that, but if you're terminating an employee or a group of employees, you need to think about everything they need to get paid at the end of employment, getting them the proper information and notices. They're going to be perhaps eligible for COBRA. I've had other situations coming up where people are, of course, thinking about and worrying about the retirement plan that they have through the company, and if they've taken out loans from that, the implications for that if the employment ends. So there's all sorts of things that can come up with the end of employment. And so we just need to make sure that we are first moving through the furlough process properly. And then if circumstances change and we have to proceed to a layoff, we then have to work through the layoff process. And this is a little bit unrelated, but Charina touches back on the key takeaways. You know, as we're working with employees in all of these situations, we have to treat people fairly. And, you know, I get nervous when we start talking about, you know, looking at people differently based on immigration status. COVID is a health issue. You know, employees have certain rights to confidentiality and privacy in their medical information. There are all sorts of disability laws that apply in certain circumstances. So this is just a minefield of issues, and everybody needs to be moving very carefully and making sure that they're considering all these issues as they try to figure out what to do going forward. I think we've emphasized that.
Okay, and then does a furlough require an expected return to work date?
Not that I'm aware of. I've seen furloughs that there is an expected return to work date, but mostly what I'm seeing right now are indefinite furloughs or sort of a moving return date. So initially people were placed off work and we had initially, I think, a 2-week shutdown order here in our area. And so people were thinking, okay, well, we'll be back in 2 weeks. And then of course that had to be extended and has now been extended yet again. So we have sort of moving return to work dates, and other furloughs right now are just indefinite. You know, we'll just keep in touch and let you know when we have more information about when we might be able to return to normal operations.
But, you know, as I've been talking to clients and I ask them, do you have an idea of when you're going to be bringing employees back? There's a lot of considerations they have to make, right, as they're bringing folks back into the workplace. One being safety, compliance, privacy issues. I think you mentioned before about testing people, you know, taking their temperature before they come into work and things like that, right?
Yeah, so we're still struggling with that here. We're getting guidance from the CDC and to some extent the California Department of Fair Employment and Housing that we may be able to take everybody's temperatures when they walk in the door. There's some other concerns about whether that violates constitutional rights of employees. You know, my thought overall is safety first, and we need to make sure that we are ensuring a safe workplace because there are still workplaces that are operational, essential businesses. And I think, you know, what we all want to avoid is having somebody who is ill come to work because they feel they have to, and then having an outbreak and having more people get sick, which impacts not only the business, but whoever's being served by that essential business. So the ripple effect, I think, is what we're all trying to prevent. But these are the questions that we are dealing with daily.
Okay. And then as we wrap up our webinar, Cliff, do you have any final words for the?
Yeah, I kind of want to echo my preface and just, you know, and really what Erin said now is very pertinent as well, is that, you know, on the one hand, employers, you know, they want to keep to the immigration regulations, and of course they should. But if that means, you know, that's going to make the employees come into work when they shouldn't be and they're sick, and it encourages them, then that, you know, that's a big decision that, you know, employers are going to have to make, because in the past it was really a decision of, you know, whether we're compliant or we're not compliant, and now it's just might even be a bigger question of safety as well. And I think that's, you know, leads into, you know, we have a lot of conservative and a lot of, you know, less conservative, you know, recommendations, which just have to be taken into account with all in the totality of the situation. And that's why it's imperative that, you know, everybody contact the employment lawyer, the immigration lawyer, whether it's us or whether it's not us, because it's very important to get all the ducks in a row, so to speak, because, you know, that's going to be the key to making the best decisions.
Good words of advice. Erin, any last minute words for you?
Other than that, I'm just so appreciative and thankful to be talking to you, as I said at the beginning, and everyone who dialed in today to listen to us, and everyone that we're continuing to work with. I just really appreciate, generally, I think people are worried about doing the wrong thing, but as they should be, but mostly I see people all across the board trying to do the right thing.
That's great. Well, there's information here about how you can reach us. Also, if you want to replay this and share it with your colleagues, it will be available on our website and on our YouTube channel. But I'd like to thank everyone for participating in the panel, which I feel was super informative. So thank you, everyone.
Thank you, Charina.
Sure.
Thank you.